to the forefront. The Honorable Prime Minister has time and again talked of having a strong IPR regime where one not only recognizes one's own IPs, but also respects others' IPs. And in this entire scheme of things, all of us have a major role to play. It's not only us as the Government of India, because all the IP laws are central laws, but the enforcement agencies at the ground level, the police officers, the prosecution team, the customs officials at the borders, all of us have a crucial role to play in ensuring enforcement of IPRs. If I may point out, when the Home Minister was speaking, the Honorable Minister talked about terrorist activities being funded through counterfeiting and piracy. And this is a sad truth of life and something that India cannot close its eyes on. It's not only just a question of industry, of entrepreneurs, of innovators, of creators losing money. It's not just a question of other people cheating them, siphoning off their works. It's not just these people not enjoying the profits of their labor, but it's this money which gets channelized into nefarious activities, including terrorism and all of the antisocial activities. So it's really crucial, it's really important that we understand our role. Now, before I start on the presentation, just a brief overview of IPRs and the way the government is moving ahead, the way India is moving ahead on IPRs. I would just like to point out one or two things. We recognize that at the end of the day, IPRs and the enforcement will take place at the Thana level. It's ultimately going to be the SI on the spot, the SHO, or in certain cases, the Deputy SP or the CO, Circle Officers, or the ACPs will be responsible for conducting the actual raids, for taking forward things. But getting that message across was really important. And that's why this has been an attempt to bring all the states on board, to bring everyone together so that at least you can realize the importance and the crucial role that IPs and IPRs play in our lives. And then when you go back, we will be with you in taking forth this message, spreading it to all the districts, to all the police stations, to all the rangers in the states, so that there is awareness, and when something like this crops up, it is the police officials and the prosecution wing which immediately act upon it, and obviously the customs authorities at the borders. This may be the only session where we will actually talk of patents and other IPs also, but that's just to give you a brief overview of IPs. And the next 3 days we'll be delving deeper into trademarks and copyrights, which are the two principal acts which are not only covered under where you have criminal remedies and which are cognizable and non-bailable offences, but also under the Prevention of Money Laundering Act, where they are scheduled offences. The National IPR policy, the Honorable Home Minister and the Commerce Minister commented about it, was finally adopted by the Union Cabinet on the 12th of May 2016. And so, realizing the need for an in-depth study of the IPR scenario, the think tank was constituted. We had a draft policy, consultations with various stakeholders. In fact, there were 5 foreign governments which also commented on this policy. Their views were listened to, taken into account, and then, and I would like to clarify this out here. The policy is India's policy. It's our domestic policy. It's a policy made from the point of view of India and Indians, and what is good for us, what is good for our industry. And that is the way this policy has come about. We have laid out a few copies on the tables. Obviously, a soft copy is available on our website also. We are trying to publish it in other languages also. Right now, it's in English, Hindi, Gujarati, and a few other languages, but we are trying to publish it in other languages in the coming days too. So obviously, it has action points. Whose responsibility is it to implement those action points? That's all laid out in the policy. These presentations will be made available to all the delegates on the third day. We'll be giving you soft copies of all these presentations, so you need not really, copy down anything. So this just lays out the vision and the mission statements of the policy. The clarion call obviously has come up time and again, which is to make sure that we have a creative India and innovative India. These are the 7 objectives, ranging from awareness, the generation of IPRs in India, while trademarks, 90% of trademarks are filed by Indians. But in patents, that number is still low, despite the fact that research takes place. But most of the IPs are owned by foreign companies or foreign countries. Why this is important? We talk of cross-border trade, oil, our import bill. A study done a few years ago, 2013, showed that India was earning around $0.5 billion from royalties, but the outflow was over $4 billion. So Maruti is an Indian car, but we pay royalties every year to Isuzu, which is a Japanese company. So at the end of the day, it's not just the production, it's this IP, the intellectual property, which is going to give our country the sound economic footing, the monies, the revenues that flow from it. That's why generation of IPRs is critical in terms of the entire regime. Then obviously the legal and legislative framework, which is well entrenched, well laid out, and our judiciary has been extremely proactive in protecting IPRs. The administration and management, which would be the IP offices where you have the registration or granting of IPs. Commercialization. In India, the commercialization of patents, for instance, is very low. The world over, the average is around 3%, in India it is even lower. So we really need to look at all these technologies and how can we commercialize them. Because unless we do that, we don't realize the value, economic value from those IPs. Enforcement and education, which is where your prime role comes in, and to ensure that we are able to enforce our IPs. And then the last, which is human capital development, the capacity building in terms of manpower, in terms of organizations, infrastructure, and as the Honorable Home Minister was kind enough to comment and commit to undertake training on IPRs in all police academies across the country. And that's going to be a huge game changer in terms of the entire IP enforcement regime. Some of the early achievements since the policy was introduced in terms of clearing our backlogs or the IP awareness programs, there has been a remarkable increase in patent and trademark filings, simplifying of procedures, the augmentation of human resources, and the synergy that we have achieved between various IP officers. So in terms of backlog, the Secretary had commented upon this earlier. We have increased our manpower from 130 patent examiners, almost 5-fold. Now there are around 600 odd patent examiners. And since all of you are government officers, you would appreciate this fact. In fact, the year 2015, when we started this, we had absolutely no idea how to recruit them. The UPSC does not recruitment, but they are Group A posts. So Class 1 posts to be recruited, to devise that examination, and to do it without any interview. To have a 2-stage examination, we had 80,000 odd applicants, all engineers, all scientists who applied for these posts, conduct the exam, and then they have joined, and now they are actually giving us, producing examination reports. Last year, because of this recruitment, we were able to enhance our examination. So when you have a patent application which is filed, it has to be examined first against global databases. That itself is a complex job, and that's why we have a huge pendency of almost 7 years right now in terms of examination time. And we plan to bring this down to 18 months. And for this was the most crucial factor. So last year, we've already had a 70% increase, and this year, in just the first 4 months, there's been a 400% increase to over 16,600 odd applications being examined in the first 4 months this year. So this number is going to gallop, and it's going to increase more and more. And we hope to reach a target of 18 months for examination time by 2018 or 2019. And the important part is that in almost all economies across the world, US, Japan, Europe, which are the major IP economies, the time taken to examine an application or first action is about the same, 18 months. So we will be touching global benchmarks in patents by the next year or two. Trademarks, we have already had a massive improvement. We are amongst the best today in the world in terms of examining trademark applications within the first month of their filing. And this has been a major success in terms of improving our IP systems. Startups, there are specific provisions. All of you are aware of the way the Startup India mission, and all states have taken up startups as on a mission mode. We are providing rebate in terms of fees for trademarks, patent filing. We expedite the examination of patent applications. We have a scheme whereby we fund the lawyers or the facilitators who will help the startups file for IPs, patents, trademarks. And the numbers are there on the screen, indicating the kind of interest, interest that startups have and the way they want to protect their IPs. Because they have the ideas, they have the zeal, but it's up to us as government to ensure that their ideas are not stolen. And we have a major role to ensure that these young entrepreneurs are able to enjoy the fruits of their labor. As you can see, the figures, the blue is last year and the orange or red is 2016-17. There's been a remarkable increase in trademarks. Examination, for instance, has shot up to almost twice, from 2,67,000 to 5,32,000. And registrations of trademarks, 4 times, 65,000 to over 2 lakhs and 50,000. So these figures actually reflect the kind of work that has gone into this entire scheme of things over the past 2 years. And we hope to clear our entire backlog of trademarks in the next year or so, even at later stages, even on the patent side over the next 3 years. So this is continuous work in progress. And as we move ahead, as we clear our backlogs, as more and more enforcement takes place, we hope to see a further rise in filings. Now, 2 pointers out here. One, Indian filings of patents, of the total 45,000 patent applications that we get in a year, only 30% filings are by Indians. 70% are filed from abroad. This is a trend that needs to be reversed. A few years ago, only 20% filings were by Indians. That has now gone up to 30, but it's still low. 13,000 applications are being filed by Indians. We need to see this gallop and shoot up much more. This will happen when, one, we clear our systems to ensure that we dispose of those applications in a timely fashion. 2, we ensure enforcement. Now, even as I move ahead, I would like to clear, patents do not provide for criminal remedies. It's a purely civil right, it's a purely individual right, and there is no criminal offense whatsoever in a patent. So that should be very clear. The only reason I've brought out patents before you is so that the entire IP regime requires a basic understanding of patents. In fact, in your folders, in the bags, you'll have a brochure, a green brochure, which explains various IPs in a very simplistic kind of fashion. And for those of you who are interested, I mean, obviously, we can go as deep as you want. There's no dearth of information, of knowledge in this regard. Copyrights again, now we have taken up copyrights with a zeal, and by the end of this year, we'll see a remarkable jump in the figures out here. In fact, 2016-17, the reason why these figures are still low, because we were switching over from one ministry to another. We were switching over our office from one building, and we took up a new office. And so for almost 4 to 6 months, there was a hiatus in this entire scheme of things. Designs obviously are still low, but given the design consciousness and the increase in design consciousness in India, this is something we are trying to now encourage and inculcate design thinking in the country. IPA awareness, this is more in terms of the younger generation, schools, colleges, universities, and the industry. We have planned 4,000 programs. We already launched them, started having these programs, and I'm grateful to the National Police Academy. We have had training programs for police officers in NPA. in state police academies in various states. These awareness programs are primarily for the students, to make them aware, so that tomorrow when they want to download a song or download a movie from torrents, they hesitate just that bit and realize that what they're doing is immoral, is illegal. It is going to help someone who is not interested in the country, who is not interested in the economy. And once this awareness comes in, we will find more and more children, more and more of our younger generation taking care to protect IPs, and as they become aware of their own IPs and start respecting others' IPs, it will in turn inculcate this innovative streak in them also, and they will then be able to move ahead as entrepreneurs and as innovators. Obviously, the programs are going to be in regional languages because our aim is to reach out to the students in their language and what they can understand. There's just some of the material, so made it as colorful and as cheerful as possible so that we can interest the students. And in fact, some of the films that we were showing out here, cartoon characters and others, are things that the industry has come up with. And I must thank the industry because it's not that we are paying them for anything. The industry has been doing this on their own volition and have actually now come up with campaigns and drives to create awareness on piracy and counterfeiting in the country. TISC, or the Technology and Innovation Support Centers that the Commerce Minister pointed out, and we've already had started one in Punjab. Chennai is also coming up, the Anna University. In fact, if these two are established and are well entrenched, we hope to see WIPO supporting us in many more such TISCs across the country. We would like to have them as a network in all states of India to see how we can support innovation, support technology, provide best practices globally, provide information databases that can be of use to our young and budding entrepreneurs and innovators. Now, the Global Innovation Index is an annual feature for the last 10 years that's issued globally, which ranks various countries on the basis of innovation. India's rank, unfortunately, in 2015 was 81st, pretty down, low down in the entire rankings. And that's when the government of India took it up. Last year, our ranking shot up 15 places to 66th. This task force was constituted, they've given their report, and now we're working on those recommendations. In fact, we are now coming out with a new industrial policy which will contain these recommendations also. This year, our rank has risen up further to 60th. And as we move together, and I must say, the key movers, the key drivers will be the states who are actually going to create that ecosystem where more and more innovation can take place. We will see India's ranking obviously go up further on this front. While IP laws are domestic, they have only territorial jurisdiction. So a patent law from India will have territorial jurisdiction over India only. Similarly, the Trademark Act. But given the fact that IP has a lot of international ramifications, you must be hearing cases of medicines or drugs, etc. And so it's important that we have an international reach. And this is something we have been actively pursuing, tying up with other countries, tying up with organizations across the world. Plus, all the MOUs, all the agreements that India signs with other countries, with other organizations, we make sure that it does not contain any clause which can harm our interests in terms of IP. So that's why there are almost 100 MOUs that we examine every year. And this itself is can get pretty complex at times. Okay, the Marrakesh Treaty, just to point out, India was the first country, and this basically provides for visually challenged and the blind people, so that we can make available all the books and all of the copyright material to them without infringing the copyright laws. And this has been, India has been the key mover on this treaty. Okay, enforcement, these are a few issues. That was a good reminder. We should not watch television too much. Okay, these are a few of the issues involved in enforcement that we need to look at. I really will not go into them in great details because over the next 2 days we will be looking at various issues. But obviously, we have to work with the state governments. It should be very clear that, and at the Government of India level, we recognize and respect the fact that at the end of the day, change is going to come about when the state governments are involved, when the UT administrations are involved. And that is the only way. We can only at best act as facilitators. Specialized cells for IPRs in colleges and universities, in industry, so that they can take care and propagate IPRs. Creating the awareness, fact-finding studies, training. This is something which has been brought out again and again. Assistance, technology is obviously something we are all using, so, and obviously interagency coordination. This is not only between agencies from different states, different departments, but also within the same state government. So it could be a CID, it could be an EOW, it could be another wing of the state police, and tying up with each other, sharing information so that we are able to achieve the best results. So these are just some of the programs that we have already organized over the past 1 year, and I must say that the respective state governments and the police departments have been very proactive in coming forth with these programs. So it's Andhra, UP, Bengal, Madhya Pradesh, Telangana, and obviously we have reached out to other states also, and these programs are continuing. These programs are, we would definitely like them to be at the cutting edge. So while we organize a number of programs in the state, we are looking forward to training the police academies, training their people, training certain master trainers, so to say, in the state police, who can then go ahead and train further down the line, right till the Thana level. Because it's really crucial that the cutting edge, which is the Thana, is aware of the procedures involved. So we've, and then obviously in the NEPA Academy, and I must say that both the NEPA and NPA Hyderabad have now included IPRs as a part of their curriculum, and in the next, the training programs, there will be modules on IPRs. So this is going to be, again, a huge thing in terms of creating awareness on IPRs. For judges, we have reached out and we have started holding programs with the National Judicial Academy at Bhopal. In addition, there will be more training programs. This is again something we are tying up with WIPO and the Niti Aayog. So we are planning more such programs for judges also, so that when these cases go up before judges, these specialized laws are something they are familiar with, and it leads to that much better dispensation of justice. Just a few snapshots from the police training programs that have been organized. And in fact, it's these training programs that have helped us shape this module to realize what is needed and how should it be delivered. Who would be the best speakers in terms of law firms, in terms of other experts into delivering and giving the message. This is a toolkit which has been prepared in consonance with FICCI. And again, this is an industry initiative. It's not that the government has funded it or the government has, it's entirely an industry initiative by FICCI and their partners. This basically lays out the law, trademark, copyright, and the main two laws in terms of IP and criminal remedies available therein, and what should be the procedure that should be followed. Now, one thing should be clear, that each state would have some differences in terms of the procedure, in terms of what they, who would be the competent authority, for instance, to approve a raid. In a district, it might be an SP, it might be an ACP, there would be variations state to state. That's okay, you can always adopt it and adapt this toolkit, but this lays out the basic checklist, lays out the basic points on what to be careful of when you conduct a raid, how to conduct a raid, how to make sure that you achieve success and conviction when you prosecute that particular case. So there would be more on this enforcement toolkit in this workshop also. Interagency coordination, all of us face it, all of us realize the importance of this, and the sharing of information amongst all the departments, agencies who are responsible for enforcement is a critical part. And these are just some of the agencies who are involved in this entire IP regime. And we have been working closely with all of them to achieve the best results and synergy. Okay, online copyright piracy is again a huge thing. A few years ago, it used to be DVDs and CDs, and you could actually go to the market, conduct a raid on a video parlor, and be able to catch the, so to say, the person who was pirating and selling those cassettes or DVDs and CDs, etc. Today, there is just no physical manifestation of this crime. It's all online. It's a signal that goes. So how do you tackle it? We have to be different. We have to take ways in which we are able to counter this. And this is a major issue. For instance, if there is a URL and you block a particular URL, the same movie, pirated movie, starts showing on a different URL the next day. So blocking of a URL does not help. But is there a way in which we can take care of this problem? Blocking of websites is something which is possible. Now, under our IT Act, if you want to block a website, barring for a very, very limited few purposes, which is basically national security or certain other child pornography, for instance, you require judicial orders to block a website. Is that a viable solution? Maybe, but it's slow. It will take its own time. But this is one of the, I'll call it an innovative jugaad that we have actually brought in. All websites are supposed to fulfill KYC norms, know your customer. Now, the industry has helped us identify a few rogue websites which do not, or rather which have almost 100% infringing material on their website. It could be the torrents websites and any number of such websites. We have gone to the domain registrar, which is under NICSI, which is a specialized agency for this. And they in turn block these websites, not because they have infringing material, but because they do not fulfill their KYC norms. All such websites are under fictitious names, fictitious addresses. So using these KYC norms, we have been actually able to block 6 websites, and now more are in the pipeline. It's not easy. Once a website gets blocked, to again upload that material is not going to be easy. It takes, a couple of months, especially to again bring that name into the public domain. That look, this is the name where you can go and download a movie. So this has been one of the successful experiments, and we certainly hope to continue this further. Now, unfortunately, we can only take action against domain names with the .in extension, which is websites registered in India. Most of these websites are registered abroad, but they beam their content into India. How do we tackle them? This is where we need the international community to get together. There is a body, ICANN, in Los Angeles, which is the kind of federation of all these domain registrars. So that is one which needs to act on this. Other foreign governments need to act upon this. So even while taking down a rogue website because of infringing material may not be easy, KYC norms is something which can be easily used. And if they do give their correct details, well, we can always file cases against them and take them, and then take action against them. So this is one way in which we can take action on online piracy. Now, another way which our courts have found is John Doe orders. John Doe is basically, Ashok Kumar orders, or those of you who have seen the movie, Amitabh's movie, Main Azad Hoon. It's an unknown person. John Doe is an unknown person. It emanates from a very old Hollywood movie, Meet John Doe. So these are orders against unknown people. The copyright owner goes to the court, says that, look, this is my movie, and I don't know who is infringing it or who is pirating my movie. And they get these John Doe orders, and which are then implemented through the internet service providers, etc. Just a brief of the various IP acts. They've been listed out here. You'll see that criminal remedy is not available under the Patents Act and the Designs Act. These are the only 2 acts. The reason behind this is very clear. Patents are a very, very complex job. Even for the patent examiners and controllers to identify whether a particular patent exists or not is very difficult. A mobile handset, for instance, A mobile handset can have as many as 10,000 patents, one mobile handset. To be able to identify and differentiate whether there is a patent existing or not is a very complex job. And that's why this has been left only to civil jurisdiction and not for criminal jurisprudence. Similarly, designs, because which is more or less a fallout of patents, and that's why it's been kept out of criminal purview. But the other acts, copyright and trademark primarily, which as I said also are covered as scheduled offences under the PMLA, Money Laundering Act, and the others. GIs is something which is again of importance because our rural artisans, our farmers, the Honorable Minister of State, Mr. Rijiju, was talking about various GIs from the northeast. Kullu shawls, Banarsi saris, you'll have a lot of fake products that are sold in their name. So it's actually cheating our poor people. The Bastar Dhokra that the memento that was given comes from the tribal areas of Chhattisgarh, from Bastar. So anyone can simply make a replica and start selling it as Bastar Dhokra and say that this has come from the tribal hinterlands of India. So this is actually cheating and ripping off these poor people, the artisans in these villages, the farmers. Basmati, for instance, Basmati rice has a GI, Nagpur oranges, the Tirupati laddu, maybe that is the smallest area for any GI in the world, only that kitchen from the Tirupati Ji temple. So it's really important that we recognize and empathize with these people, and what action can we take to protect our brethren, to make sure that no one else benefits from their name and from their hard work. Patent issues, we will not be touching upon them otherwise through the conference. Just to give you an idea, evergreening basically means you have a patent which has a life of 20 years. Now, how do you extend this life? Because you want to continue selling your medicines at an expensive rate throughout life. So you make minor changes. Red, you convert to green. Green, you convert to yellow. It's a pill, you convert to a liquid form or something else. So, you make some minor changes and you again take a patent. So it's an evergreening of that patent. Insulin, for instance. There has been a patent on insulin in America for the last 100 years. Now, there is no change. It is the same medicine, it is the same efficacy. But this keeps the prices of drugs artificially high. Someone who has innovated, someone who has worked hard on creating a new drug or made substantial changes, yes, he should enjoy the fruits. But patent is for a limited period. And the very meaning of patent is that in exchange for getting this restricted monopoly for 20 years or so, you are allowing your entire information to be placed in public domain so that someone else can use this information for further research. And after 20 years, this information becomes freely available in the public domain. Okay. It's not that other countries don't have, they have similar provisions. They just don't call it this. Although, for any one of you who would talk about patents, Section 3D would be one thing which would come up again and again. And this is something which is an innovative feature of our Patents Act. Compulsory licenses, the international or multilateral regime is TRIPS. This is totally in line with TRIPS and the Doha Declaration. A particular medicine has been patented in India, but is not being manufactured or provided to the people, or the rate is abnormally high. What do? Do you let your people die? Do you let your people not have access to this medicine? No. If this be the case, and someone is, or some company is not ready to meet the needs of the public, then we retain the sovereign right to grant a compulsory license. And these are issues which have come up again and again, and recently there was a report by the UN Secretary General in 2016, September 16, in which all these points have been highlighted, and India's stand on all these issues has been vindicated. Interestingly, you have compulsory license being issued in other countries also. Germany, there was a recent CL, compulsory license issued last year by a court out there, but you won't find voices being raised against it. Compulsory licenses by other names, authorizations, and one can now come up with imaginative names also for the same. But other countries too have been issuing CLs. It's just that one doesn't name it so. So this, the only reason I'm bringing these issues before you is so that if ever there is talk of this, at least you're aware that these are red lines or these are policy issues that are engaging the government of India. Data exclusivity is another issue whereby even though there is no patent, data exclusivity on all the data that is provided by a pharmaceutical company for seeking approvals from the drug regulator, that data is exclusive and it cannot be relied upon by the regulator for some other company. I won't get into more technical details on this. Just to suffice that this is another red line which, there's a major difference of opinion on this. But this again is something which is absolutely in consonance with TRIPS. Patent linkage. Now the drug controller, who is the authority who approves drugs, does not have the mandate, or I'll put it this way, does not have the technical competence to see that whether a drug which has come before him for marketing approvals, whether that particular formulation, whether that particular drug contains a patented process or product or not. And that is why patent linkage, linking a patent to a drug approval is something which is, which again is a policy issue which is looked at in terms of patents. What you have to remember is that patents are private rights. So it's possible that if someone infringes a patent, the patent holder has the right to go to the court of law, and I can tell you, the courts in India have been extremely proactive in protecting rights. They have been giving injunctions where most courts in the world do not do so. So it's, India has evolved its own system where this part has been left to the courts, and the courts have stepped in to make sure that patents and private rights are protected. SCPs, just to tell you that when we have a mobile, for instance, and I told you that it has 10,000 odd patents. Now to take a license for each patent is practically impossible. But how do mobiles talk to each other? For that, it is important that the mobile manufacturer is able to use all those technologies, common technologies, so that all mobiles from various companies can talk to each other, but pay the license royalties to the concerned patent holder. So it becomes essential to that particular product to meet that particular industry standard, with the condition that royalties will have to be paid. So it's not going to be free. It's not going to be, so to say, an infringement in that sense. Various issues, I won't go into that. So I just wanted to give you a brief overview of where we stand in terms of IPs, and because patents especially is a topic we will not be dealing with over the next 2 days unless there are any questions, and unless there are any particular views on this. We would be more than happy to discuss these issues with you and to take forward the discussion out here. Thank you.
Thank you, sir, for your valuable insights. Effective government policies and practices are harbingers of securing a strong IP regime in a nation. Under your able guidance, we are positive that we will be the torchbearers of a creative India and an innovative India. May I now request Mr. Vipsha Banerjee, our AVP, to kindly give a token of appreciation to sir.
Thank you.
This concludes our first session. Thank you, ladies and gentlemen.
Yeah. A very good afternoon, ladies and gentlemen. The next topic for discussion is building respect for intellectual property. The session will be taken by Ms. Louis van Gruyen. Ms. Louis van Gruyen was admitted as advocate of the Supreme Court of South Africa, joined the World Intellectual Property Organization in 1996. Prior to her appointment, Ms. Gruyen was a public prosecutor in the criminal court, lectured law, and was the Registrar of Patent, Trademark, Copyright and Designs of South Africa. Presently, Ms. Louis is Director of the Building Respect for IP Division. She is responsible for policy dialogue in the context of WIPO Advisory Committee on Enforcement. May I now request Ms. Louis to kindly take the session.
So I don't know if it's working, but it seems it is. It is really a great honor and pleasure to represent the World Intellectual Property Organization at this very, very prestigious occasion. And it's a pleasure to share with you our work in the context of building respect for IP. You may wonder why we talk about building respect for intellectual property, because this division was previously named the Enforcement of Intellectual Property Rights Division. But there was a slight change, and I will explain this to you. Is this not too loud? Let's test it. I think this will be better. I just want to give you one or two words about the World Intellectual Property Organization, which is really the global forum for intellectual property. And some statistics, as you may know, we are responsible for 26 treaties in the organization, dating back to the Paris Convention of 1883, the Berne Convention, and many other treaties and conventions. 188 member states, and we have, of course, staff coming from around 118 different countries, more than 1,200 staff members. So it's a big organization, and we are very, very keen to follow the developments in your country. I also noted when Mr. Agarwal presented the new IP policy that there is really in the point of departure a similarity with the mission of the World Intellectual Property Organization. And it's really to stimulate innovation and creativity. And I noted with pleasure that you had, in the last number of years, an increase of, enormous increase in your local patent filings. That in itself is already showing the development in your country, and I think you have all the reason to be very proud of this. Now, quite recently, I was requested to make a presentation at the into the Telecommunication Union. And I did some research and I found that there's even a website where you get some guidance to determine whether your telephone is authentic or not. And they give you a number which you can punch into your telephone to test whether you get the EMEI number, and then you know your telephone may be authentic. Interestingly enough, some years ago at a national workshop in one of your neighboring countries, we did this exercise with the police and customs officers, and they were absolutely shocked that in a room of around 100 enforcement officials, 50% of them had fake telephones. But they didn't know it because they paid the original price. These telephones had infiltrated the official supply chains. Now, I can tell you one thing, we had their attention and they felt very concerned. And this is a big problem that we have today. Before we had fake goods relating to only luxury goods. Today we have a completely different scenario. And I remember it was maybe 10 years or so ago, I was fortunate to participate in a regional event for judges of 25 Asian countries in the Taj Mahal Hotel in the same area. And the local representative of Unilever had just spoken to the hearts of these judges because they realized that even 1 rupee sachets of Unilever shampoo was counterfeited. So in other words, the poorest of the poor who couldn't even buy a whole bottle of shampoo was confronted with counterfeit goods right at the grassroots level. And this is really shocking. We are all consumers and we are all vulnerable. And very often we find unbelievable prices only to get unimaginable results. And this is really a global problem. The photos that I will show you now is in fact evidence in a court case in one of your neighboring countries where beverages were manufactured in absolutely atrocious and appalling conditions and sold, of course, by the crates to people like you and me. Now, what are we going to do about this? Not long ago, we had one of our police officers from one of the countries in Africa who had participated in one of our events. And he told us that they had 80% of beverages faked in the official supply chain. Now, what do? Where must you now go and buy your bottle of water? And how careful must the consumer be at the end of the day? We all know we have to be careful, but at some point, how do you know? Today, we sit with more and more sophisticated infringing goods. I heard this morning that one of our dignitaries said, we don't want to lose the quality of the films, etc., that we like. But today, you don't lose the quality. That's the problem. And these goods are unauthorized. And the money do not reach the pockets of those who had invested creativity. And that is a big problem. In my country, South Africa, we have wonderful, talented people who cannot make a living because of piracy. And the government had heavily invested in this movie, you may know it, Tsotsi. It was a global award winner. And the government realized that you could find a copy of Tsotsi on every street corner. And the government realized that they had no returns on their investment in this movie. And it really changed the perspective, because the enforcement of intellectual property rights really got a boost after this particular incident. It is very close, and it's costing the country dearly. Now, you, of course, with your fantastic film industry, you are suffering. And we had the pleasure of some of your experts at the advisory committee participating, raising concern about the losses to the country due to the infringement of these rights. It cannot continue like this. Now, we all know, and in most countries, in the majority of countries, it is illegal to sell counterfeit or pirated products. We all know that. And some people will say, yes, this came to us through the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights, which was negotiated in the framework of the World Trade Organization, the predecessor. But it is not true. And I think if you look at your own legislation, you will trace back criminal enforcement provisions relating to copyright, most probably trademark, to many years ago. So this was not inflicted on us through the TRIPS agreement. We know as far back as the 1800s that it was viewed as deceit and as pirates under copyright legislation in the UK and in other countries. So this is nothing new. And we have case law developments dating back 1800s, where we had honorable justices saying, it is deceit, it is unlawful. You cannot sell your goods, the goods of another person, under the pretense that they are your goods. It is a deception. It is not permitted. And that is at the backbone of our legal systems for many years. And I followed your case law developments in India because I use your case law developments in neighboring countries. And you have a wealth of case law development. I fully agree with Mr. Agarwal, because we followed, and the courts are proactive, and they have a whole pool of wonderful decisions already in your country. Some, of course, relating to civil. It's not forcibly only limited to the criminal enforcement of intellectual property rights. But here we are concerned as well with the criminal enforcement of intellectual property rights. And there must be reasons why one would apply criminal sanctions to what is commonly known and perceived as private rights. Now, why would law enforcement dedicate scarce resources to what is commonly known as private rights? Only when the criminal law protects private rights if there is a public policy element involved, like with any other crime. And if we think of what is the public policy element, I give you a couple of ideas. We think about job creation, we think about tax and customs income, public health and safety, the prevention of corruption, organized crime, and money laundering. We already heard it this morning. Even in the speech of the Honorable Union Home Minister, we heard these things. It's nothing new. We think about foreign investment and investor confidence. How are we going to grow in a sustainable way if we don't have an environment within which the right holders can use their rights and have their rights protected? Why would somebody bring their business to this country if you run the risk of the infringement of your rights and you find yourself without remedies? So this is very important. And finally, also to think about your international trade relations, and you want to avoid trade sanctions because you do not comply with obligations under international agreements. This public policy element has already been recognized in the Rome meeting of the World Health Organization. I attended there in 2008. The meeting concluded with the following: counterfeiting medicines is a vile and serious criminal offense that puts human lives at risk and undermines the credibility of health systems. Now, I have to add that the definition of counterfeiting in this context is broader than the TRIPS definition, where we talk only about trademark counterfeiting, which is willful and on a commercial scale. For them, counterfeiting would include also adulteration or spurious products and the like. So the definition is a bit broader. And I can also assure you that during the negotiations of the TRIPS agreement, although developing countries did not agree on some of the substantive provisions to be included in the TRIPS agreement, they were in agreement that we needed remedies and sanctions to protect consumers and the rights of the right holders. In other words, there was agreement on the adoption of Part 3 of the TRIPS agreement, although they didn't agree to all the substantive provisions in Part 2 of the TRIPS agreement. Now, I believe we also have some prosecutors here, and as you heard, I started my career in the criminal courts. Now, I don't want to preach to the converted, but we all know generally that no criminal prosecution will be instituted unless there is reason to believe that the persons, the accused, as we call in South Africa, conduct or the potential, the alleged accused conduct constitutes an offense, and the readily available admissible evidence will probably be sufficient to obtain a conviction. Once you have that, you decide, am I going to prosecute this alleged accused, or am I not going to prosecute? And even where a successful prosecution is probable, the prosecutor, where he or she has the discretion, might decide not to prosecute for 3 very good reasons. The prosecution will not serve the public interest. So not in every case where you can show there was the infringement of this item, you are obliged or forced to institute a prosecution. It has to be in the public interest. Or the person is subject to effective prosecution in another jurisdiction, then we will not prosecute. And there are adequate non-criminal alternatives to prosecution. Generally, that will influence your discretion whether you're going to prosecute or not. Now, the one important point here, when you determine what is in the public interest, is not to look at intellectual property laws in isolation. You are experienced law enforcers, you know your legal framework. IP laws are not a separate category of laws. It is commercial crimes like other commercial crimes, and we have to look at the relation with other applicable laws. And we find that there are overlapping crimes or alternative charges, and they can be very serious charges, including fraud, tax evasion, organized crime, money laundering, standards, and the like. So even if the main message that you take away here today is that don't look at IP in isolation, because very often you may not even have a right holder to assist you. You can fall back on a whole host of other laws if you want to protect your consumers or, of course, the public interest, as I mentioned. But we have another problem globally, and Mr. Agarwal also mentioned the diligence of the government to make public awareness. If you go to this website, you can buy only one thing, and you can buy fake gifts. Now, everybody visiting this website is aware that what you are buying there is fake gifts. And this man made so much money. I saw an interview with him when he was in prison. And he said, and even if I know what I'm doing is wrong, I will continue doing it because the money is good. Now, this guy went to prison for 3 years. He had to pay $14 million in restitution, and I talk about a number of years ago, and he was waiting to get out of prison to continue. It was not a deterrent penalty. And while he was in prison, I followed this website, and it said, fakegifts.com will be back. In the meantime, fake it till you can make it. Now, coming back to this point and why we talk about building respect for IP as opposed to only the enforcement of intellectual property rights, I have to mention to you that through the adoption of the WIPO development agenda, which was really driven by developing countries, we had a complete shift in emphasis because we had to establish an equilibrium between private rights on the one hand and the public interest on the other. And in the middle is the truth. Because member states said, we are in a situation where we don't comply with the objective Article 7 of the TRIPS agreement, which makes it very clear that intellectual property rights should benefit both the producers and the users of the technologies. So in other words, not the rich alone should become richer, but the poor should also benefit from a healthy intellectual property system. Now that brought about the shift in emphasis, and the approach by building respect for IP is broader than purely only enforcement. It embraces now enforcement plus awareness, because we know that we have to create an enabling environment that promotes respect for intellectual property rights through inter alia balanced policy dialogue. That is recommendation 45 of this WIPO development agenda, and it's very clear that enforcement should be approached bearing in mind Article 7 of the TRIPS agreement. Now, when we look at awareness, it is very clear that you cannot create a respect for intellectual property through punitive measures. There was Mr. What's his name, the guy from Fake Gifts. He was in prison. and he didn't respect any intellectual property rights. You have to create respect for intellectual property rights by showing the value in the framework of sustainable development of these rights. You will not just respect them because they are rights. And if you look at enforcement, the enforcement system, I can tell you that you will not create respect for IP through the enforcement system alone. Because if you don't have certainty in your legal system, certainty of detection, certainty of prosecution, certainty of conviction, and certainty of a deterrent penalty, people will try their luck. Because as long as the docket can disappear, as long as the policeman can take a bribe, as long as you can convince the prosecutor not to prosecute, or the judge is giving a slap on the wrist, people will try their luck. And the state has to prove beyond reasonable doubt, and it might be very difficult if you only rely on the support of right holders who may not find it particularly in their interest to support a long and tedious process, not knowing what the outcome will be. And if exhibits can disappear, etc., it will not help to use the legal system to create respect for intellectual property rights. When we look at what are the obligations in terms of the TRIPS agreement, we find them in part 3, and I'm not even going to discuss it because we know through the presentation of Mr. Agarwal, you tick all these boxes already. In fact, you have gone beyond what is required as minimum standards by making criminal sanctions available also to other fields of intellectual property and not limited to willful trademark counterfeiting and copyright piracy on a commercial scale. Now, I'm just going to give you a couple of words about the WIPO Advisory Committee, because the mandate of this committee by our member states is to work with organizations and the private sector to combat counterfeiting and piracy through education, assistance, awareness, and the like. And it's with great pleasure that I noted how the private sector is in fact supporting the government, like the FICCI initiative, to create a tool that is useful for law enforcement. This is exactly what we should do because we have common interests in the enforcement of these intellectual property rights. I will leave you the slides so you can leisurely look at the history and the involvement of the discussion topics in the advisory committee. And please note there were sessions of particular interest to law enforcement, like for example 2007, where we looked at cooperation, coordination at the different national, regional, international level relating to criminal enforcement. But then following the adoption of the WIPO development agenda, we saw a shift. And I am just going to highlight the 3 main areas which member states had mentioned. Member states said you could never make progress in addressing counterfeiting and piracy if you do not understand the infractions and the motivations for the infractions. In other words, you have to look at socio-economic development. You have to look at poverty. You have to look at pricing. You have to look at pricing structures. You have to understand that when people are poor, they are tempted to buy goods that may not be original. You have to look at all the elements, and then you have to take steps. Secondly, member states said you have to develop a methodology to really understand the impact of counterfeiting and piracy. Because if you can go to your government and you say, we are losing X% trade, we are losing so many jobs due to the infringement of intellectual property rights, they will be much more inclined to make resources available because we have now quantified facts and figures. Is that easy? No, it's very, very difficult because we have to rely on statistics. And where do you get statistics from? Criminals. It's very difficult. And these people are employing every methodology to escape from customs detection. So how will customs have all the information to have a clear impact methodology? It's very difficult. Finally, member states said, shouldn't you now look at alternate methods? Why is it so expensive to buy certain copyrighted works, for example? Don't you think if you make them available affordably, that people will not be tempted to buy infringing copies? And since this time, we have wonderful examples of changed business models. We know, for example, that today you don't have to buy a whole CD if you want one song. You can buy song by song. You know that if you press the Netflix button, you have access to a whole host of copyright protected works, and you can select what you want to watch at a price even better than picking up an infringing copy on the street corner. So yes, it is an endeavor also by business in order to make goods available at a price where we can afford them and where we have access to them. Now, we from South Africa was always very hurt that when a new movie is coming out in the US, we have to wait 18 months before we can see it. Why? We also want to see it today. So there's still a long way to go in cooperation between government and the private sector in order to make progress in this regard. I am not going to give you much more about the advisory committee other than telling you there are very interesting documents. On awareness, we like to display what member states are doing, competitions, etc. We look very closely in the last session and the next session, which will be the first week of September, at institutional arrangements and what certain countries are doing to save cost in the judicial process. How mediation, arbitration can play a role. How one can, without creating a separate legal system, develop a system where you have expertise to deal with these cases so that you remove some obstacles. So if you are interested in this, the documents are there in 6 languages if you like, so you are welcome to read them. And bear in mind again that we want to showcase wonderful success stories in the area of capacity building, and I think looking back at what is happening here today, you have also a wonderful story to share with the world. Attached to the advisory committee, we do the exhibition where countries are demanding, please give us the opportunity to display what we are doing, and we do that. Awareness raising is so important, and I fully agree with what we heard. Start with the young, because to start with the old is not going to work. And the beauty of addressing the young, they go home and they talk to the parents. So this is very important. Get some ambassadors. You have the most fantastic people, and now I think of cricket. I'm a big fan of Indian cricket. Get those people to make a stand and to say we have to protect intellectual property rights, because the history has confirmed people rather listen to Tendulkars and other people than to the police officer. So get the heroes of the nation to give the messages which you would like them to follow. We also prepared a little booklet on the investigation and prosecution of IP crime, and you will see some of the topics of this booklet is in this program. Of course, it is available if you feel you would like to adapt it to your own situation for training purposes. We can make it available and even help you, if need be, to customize it for your own situation. We do a lot of capacity building all over the world, and we see the difference. And we have wonderful case books, if you are interested, for those who want to read a little bit more. We have now already in English a 3rd edition of the Enforcement of Intellectual Property Rights casebook. It's on the internet, you can download it for free. And if you want a hard copy, you can order it from us, we will give it to you. And with that, I think I end perfectly on time. Thank you very much for your attention, and I hand back to the lady.
Thank you, Louis. We appreciate the efforts and the dedication of WIPO towards building respect for intellectual property rights, and we look forward to working with you. And now I request Mr. Sushil Satpathy, Director, DIPP, to kindly give a small token of our appreciation. We would also like to have a small question and answer round. So if anybody would like to ask any questions to Louis, our volunteers will be around the hall with mics. You can please raise your hand so that we may give the mic to you.
Okay, I do that with pleasure. We, number one, we do legislative assistance upon request. So we prepare for member states provisions relating to the enforcement of intellectual property rights. We do a lot of capacity building, and we are very transparent. You will find in the report on our activities to the advisory committee a list of each and every activity which we do, including the objectives, and we also make the program available so that you can see. We evaluate every session, topic by topic, to make sure that we remain relevant and that we can develop the programs to ensure the relevance of that. We have the advisory committee, which is, of course, the policy forum, and we have, you may note, cooperation agreements with some of the other organizations like Interpol, like World Customs, and we do big global conferences with them. You may know about the Global Congress on Counterfeiting and Piracy, which we did in partnership with these organizations as well as the private sector. Last year we had in November a big conference under the umbrella of Building Respect for IP in China, and it was a very big success. Now we have another country who had offered for one of these international conferences in Africa, it will also be a global one. We work very closely with all the IGOs and NGOs with an interest in intellectual property rights enforcement. So we attend their meetings, we participate, and we make sure that we stay present. And the main reason of cooperating with these organizations is to ensure that they have a balance in their IP system in relation to enforcement. Would you like more than that? We do awareness on an enormous scale as well. We have competitions for the children. You created a wonderful movie or you wrote the theme song. Make with your telephone a 60-second clip on how to convince your friends not to infringe your rights. And I can tell you these kids had made wonderful clips. We have poster competitions. How will you discourage tourists to buy infringing goods in your country? And the children made wonderful posters. So we try what we can do on a global scale.
Thank you. Any more questions? I think somebody there.
Why don't you come and ask your question here?
Would you like to come forward and ask the question?
The United States and several multinational pharmaceutical companies are opposing the compulsory licensing. Can you please tell what's the WIPO's stand on it, and how do you think this should not happen and why it should not happen, and details? What is your view on it?
I think I will just stop by agreeing with what Mr. Agarwal had said. It's really a very, very thorny and sticky issue. I can tell you in my own country, we had applications for compulsory licenses many, many, many years ago already. But honestly, it falls really without the scope of my responsibilities. So maybe you direct that question to Mr. Agarwal or somebody from the DIPP. Yeah. Of course, we have the provisions in the TRIPS agreement, and we advise the member states to implement them. And as you know, I think it's Article 31 provides for these compulsory licenses in the event of non-use, so that we work into the legislation if so requested by member states. I cannot hear.
Are you saying the stand taken by the big, large... No, Mr. Agarwal, I don't want you to answer this question, please. No. I want WIPO to answer this question. Will you please tell me, is the stand taken by United States and the several large multinational pharmaceutical companies, is it correct or good or bad, whatever? Please.
No,
Mr. Agarwal, sorry, I don't want your answer.
No,
I know your answer, sir.
It's not my answer. I'm not giving my answer. The only reason why I've come on stage, see, WIPO is only a UN agency.
So let the UN agency put the stand forward.
Please hold on. WIPO is a UN agency that is a specialized agency that takes care of the IP processes. It does not by itself either make laws or decide what should be the laws. Now, there are multilateral treaties that are signed by various countries. These could be under WTO, where you have these negotiations on TRIPS and other related TRIPS-related or trade-related issues. That's part one. But once those treaties have been signed and countries have acceded to them, then the actual implementation of that part, or where you have, for instance, the Patent Cooperation Treaty or the Madrid Protocol for trademarks, then the implementation is looked at by WIPO. WIPO by itself does not look at whether a particular policy is right or wrong. That's up to domestic legislation. That said, we do have the Doha Declaration in 2001 by all the countries, and it's been accepted, it's accepted by all the member nations, wherein each country retains the right to grant a compulsory license. Now, it's a right which each country has. Whether a country keeps it within its domestic laws or not is that nation's choice. Whether a country exercises that choice or not is that country's choice. So, and that's the only reason why I've come on stage. WIPO is an independent organization, and we really do not hold a brief for them. But WIPO does not have a stand, so to say, on this, that a compulsory license is a right policy or a wrong policy. That's the only reason why I've come on stage. Yes, there would be countries, there would be member nations within WIPO who may hold a contrary view. But then that's to each country to decide what they want. And secondly, because Loy is, is in the division that looks at enforcement of IPs. So maybe she would be, I guess, better suited to answer questions on enforcement rather than on the patent side. But we would be more than happy to take these questions. We would be more than happy to take these issues. And in fact, the feedback that comes from you will really help us in taking forward the entire drive, in taking forward the entire policy that the government of India makes in terms of IPs.
Thank you very much.
Okay, so you want the enforcement question, I will ask you the enforcement question. Give me the statistics and data where the United States of America has not implemented the patents and there have been infringements and disputes.
I unfortunately don't have the statistics of America, but I see as a representative of a USPTO, if you would like to share that with the statistics of when you didn't address infringements, I think.
May I also request the delegates asking questions to please introduce yourself prior to asking questions for the audience. Thank you.
So your question was about TRIPS or about enforcement for infringing content? Sorry.
I've asked you to answer, ma'am, sitting on stage. Give us major examples where your enforcement infringements have been found in the United States.
So,
Not you. Please, let her sitting on the stage answer this question.
I'm sorry, I don't represent the US. I don't have that information, sir. Obviously, it is not possible to have that type of information of each country, but as Mr. Agarwal had said, we take note of the question, and I'm sure once we have the information, it will be conveyed to you.
Ma'am, you very well showed us few pictures here, infringements in third world countries. You should be showing some pictures of infringement in first world countries like United States. Why not?
I don't recall that I have infringement photos relating specifically to developing countries. I mentioned that the infringement of intellectual property rights, notably counterfeiting piracy, is a global problem. We have it in every country. There is really no basis for any allegation that it's limited to developing countries. That is simply not true.
Thank you. We will be not taking any more questions in this session. We close the session now. I call upon Shivani from CPAM to take over for the next session. Thank you, ladies and gentlemen. Thank you, Louis.
Good afternoon, everyone. Copyright piracy is assuming gigantic proportions across the globe. No country is immune to this menace. Hence, we need stronger mechanisms to tackle the challenges faced. Our first speaker for the session is Mr. Amit Datta. He has over 18 years of experience as an IP lawyer. Presently, he is a partner at Sai Krishna and Associate. He is going to give us an overview of Indian Copyright Act. Please give him a round of applause.
Do you have a clicker for my presentation?